9 tips for defeating a motion for summary judgment. Brought to you by T-Rex Hogan at LegalSelfDefense.biz. Black belt training for people being sued by debt collectors. If you are defending yourself in a suit brought by a debt collector, there's a pretty good chance you'll see a motion for summary judgment. These tips should help keep you from losing it and your case unfairly. So let's start with a basic question. What is a motion for summary judgment? And what is it supposed to do? And more importantly, how do you stop it from happening to you? Motions for summary judgment are designed to help the court decide which cases need to go to trial. If there are disputed facts which would affect the case, then there needs to be a trial. If, on the other hand, the court decides that the material facts are not disputed, it's supposed to decide what the law requires and render a judgment. No need for a jury in that case, in other words. In debt collection cases, motions for summary judgment can unnecessarily deprive the defendant of a right to defense. So here are the tips. 1. Motions for summary judgment are controlled by the rules of civil procedure for the jurisdiction in which you're being sued, usually your state. All states have their own rules regarding summary judgment, and they are all similar to Rule 56 of the Federal Rules of Civil Procedure. This means that all motions for summary judgment will follow basically the same pattern regardless of what state you may live in. Your own state's rules of civil procedure will almost always apply to your case, and that's because in a consumer debt case, defendants are generally supposed to be sued in their home state. You can find the rule that controls your case by Googling your state's name, rules of civil procedure, and summary judgment. You should read the rule applying to your case. 2. The rules require that the party wanting summary judgment prove that there is no genuine dispute of any material fact. The person bringing the motion is called the movant. A material fact is a fact that could have a legal impact on the outcome of the case. It matters, in other words. And if there is a dispute, the court should not decide who is right or telling the truth about a certain fact. It should deny the motion. 3. You should concentrate on proving the existence of factual disputes, rather than arguing that you are right about the law. Motions for summary judgment are called fact-intensive. That's because a judge cannot make up the facts that you need to win, but must rely instead on evidence that is in the record. The judge can, however, apply the law in a way that you might not have expected in order to help you out. You shouldn't expect that, but the judge's function is to decide whether the law offers any remedy for the set of facts that you present. As I say, it's a fact-intensive motion. 4. It is not enough simply to dispute the other side's undisputed facts. You must attach evidence to your response and show the court how the evidence creates a legitimate or a genuine dispute of material facts. For more information on what is evidence, see my video on forms of evidence. 5. Or you may show that the other side's undisputed facts are not properly before the court. That is, if you show that there isn't any evidence supporting the movement's claims, you should win. In my experience, however, this is not really the most reliable way to win a motion for summary judgment. 6. Remember to follow your state's rules on responding to motions. If that means responding in numbered paragraphs that correspond to the numbers used by the movement, you must do this or risk losing the case on a technicality. 7. Many courts have local rules also. These are rules that determine the form and content of documents you give the court. Ask a court clerk if there are local rules in your jurisdiction. If there are, read and follow the one on summary judgment motions. 8. As a general rule, for debt collection motions, the movement will want to prove that you do not dispute the debt, that you owe money to them, and that you admit the amount of money is correct. So you will probably want to show that they cannot prove that you ever borrowed the money or haven't paid it back, or that they have the right to sue you, or that the amount they claim you owe is correct. You know, basically just the opposite of what they are saying. But remember the burden of proof. They have to prove it all beyond a reasonable dispute. You just have to prove that there is a legitimate or a genuine dispute about one material fact. But don't stop at one. Try to show they have no case at all. 9. As a practical matter, they're probably only going to be able to prove these things if you've admitted them. And that's one reason why my litigation manual stresses the importance of answering requests for admissions. You can find help in defending yourself. Go to legalselfdefense.biz, black belt training for people being sued by debt collectors.